It's anything over about $8 million. A jury verdict in Alabama over $8 million will get appealed for some reason, and
Mm-hmm.
it will probably get either stripped or sent back down. That's something we're always aware of here,
Yeah.
especially in cases with larger damages. And that's something I was very aware of in this big case, because our damages blackboard were at 21.8 million.
Wow.
So, that's something that was a real threat to this case and my client. But fear, going just to kind of tie that all together, I just had a feeling about this case from the beginning that everything was going to be okay.
Good.
I don't know how to explain that, but I just knew that this family needed help, and in the beginning of it, I didn't know what that was going to look like. But, I'm a fighter, and I like to be aggressive, and I like to go take what I want, and that was my mentality with this case, is that we're on the side of right. We will win. I don't know what that will look like, but we will win. It's hard to just learn information and take it in if you never get to practice it in real life. And so that's, the biggest thing is just kind of baptism by fire. Just start doing it.
Yeah.
Make sure that you're not going to commit malpractice, obviously, but just start doing it, get your feet wet, get the experience. And just over time, if you're really aware of what you're doing, I think you just become better as a lawyer.
And there is no way to learn without getting in there and doing it. I mean, we can go to all the seminars and learn all the theory you want, but until you jump in and you take a deposition and deal with not getting the answer you anticipated, or not getting what you want, or hearing that opportunity that you didn't think was going to be there, that someone might say something good for you if you softball and ask the right question. It just takes time and experience.
You always look for policies and procedures.
Yeah.
If you don't find any, you rely on deposition testimony, which is the strategy in this case, and got some good testimony on that. And so that was our case in a nutshell, and it was hard because there was no, we all think about these big cases and there's going to be some big like wow factor. Ooh, that's bad.
Right.
Like the company's the bad guy. And this was my first big case, 7+ figure case that didn't have something horrible.
Yeah.
I mean, it made it hard for my brain to process.
It happened. What we really work on those just is finding a compared to what. In other words, this is their training and qualifications or supervision compared to another company or a written standard, even if it's not a regulation that has to be followed. So, you have the American National Standard Institute has a standard. A lot of companies say they never heard of it, but like if they have more than just trucks, if they have like one we had, like in their factory floor, they followed ANSI standards. They knew what ANSI was, but they don't follow it for the driving. And then look at other similar companies and what are their standards. You look at the National Safety Council puts things out there. OSHA sometimes has a little bit, not too much, but a little bit about driving. You just look at, what can we find like in writing showing this is what reasonable companies do, and then show that this defendant is an exception to that rule.
My first piece of advice would be that I do think it's helpful when you have high damages in the case to really focus on your overall strategy. And most of the time that's going to be posturing aggressively, like you're going to take it to trial. You're not going to settle out early because the damages are so high. Too much at stake. Obviously, you have to consider venue, your planning and stuff like that. But generally, I think you should start out with, filing the case, pursuing it as if you're going to try the case, preparing it early on as if you're going to try the case, figure out your experts months in advance, get people involved. If you need trial counsel, go ahead and incorporate that person in or those people in so that they can be in the case from, the starting point and not jumping in a couple months or a month before trial. Posturing aggressively is scary for defense lawyers that don't want to try the case.
Absolutely.
Or if your venue is not great, not great for them, they don't want you to posture that way because they want to believe that they'll be able to ultimately resolve the case no matter what they do in the meantime. That they're going to have a chance to look good for their client too.